Estate planning is not only for the rich. Keeping the family farm or any valuable asset in the family can be tricky if the right steps aren't taken to protect your estate when you are no longer able to. Hello, everybody. Welcome to this month's edition of Rural America Live with AARP. I'm Christina Loren. Tonight, we'll explain why it's important to have an estate plan and share tips on how you can create one. We're also going to debunk myths about creating a will. It's not as difficult as you might think it is. And our friends from AARP are with us tonight. They've brought a special guest, estate planning expert. Michael Wallen is here with us tonight. We're going to take your questions in just a moment on the air live. Also, we'd love to hear you share your tips on how you protect your hard-earned assets for generations to come. So, we are glad you're with us. We're here. We're giving away 5 coolers to lucky on-air callers tonight. And our question of the month is, what assets do you want to pass on to the next generation? Think about that for a moment. And then give us a call and let us know. We are giving away a cooler to 5 lucky on-air callers tonight. So pick up the phone and give us a call. That number, you might want to grab a pen. It's 877-283-7570. And remember, you don't need to be a member of AARP or over the age of 50 to win. As a friendly reminder, though, you can only win one time each calendar year. And we want to let those who are winners know tonight that AARP will give you a call back using the number that you called from. May not happen tonight, but they will call you in the next few days to confirm your mailing address. Now, if you are a past winner and you have not received your cooler, be sure to return their call and provide a shipping address. AARP pays all the shipping costs for you. Now, our phone lines are open. Maybe they'll be shipping you a cooler before the night is done. Give us a call at 877-283-7570. Join our conversation. We are ready to take your calls right now. Joining us live in studio, AARP State Director for Iowa, Brad Anderson, joins us tonight. And we're glad you're with us.
Oh, it's good to be here.
What is this, your 4th time coming back on the show?
Roughly.
Okay.
Yeah, I think 4th.
All right, we've got another 4-timer next to you.
That's right. Hi, Christina.
Back by popular demand, certified financial planner Michael Wallen joins us as well. It's great to have you both back on the show. This is always one of those topics where we get a lot of phone calls, a lot of questions surrounding what we're going to be discussing tonight. Estate planning and wills. And some might think that these documents are only for the wealthy, but even celebrities are not immune to not being prepared.
Well, nothing could be further from the truth as far as the estate planning just being for the wealthy. I mean, here's what I tell people. I say, you work hard for your money. You work hard for your money, right?
True,
I mean,
true. It's very true.
It's hard to be in the catbird seat where you are. So you work hard for your money. You deserve control over your legacy. And because of that, you need an estate plan. Because, again, this is not, no matter if you're Prince or Aretha Franklin, or if you're a school teacher, you've got something to give to your family members, or maybe you've got a nonprofit out there that you want to contribute to. Have an estate plan so you can control your legacy. And then, of course, estate plans have the additional benefit of alleviating chaos down the road for your family members and your loved ones, because the more you plan on the front end, the easier it is on the back end to transfer those assets. So that's what my message is: estate plans are for everyone. That's the simple message here.
It's so important as well, because you brought up a really good point for families on the back end. The last thing you want to do is see, or to even think about the fact that your family could be fighting over these assets one day. We are going to have so many great questions tonight. We're happy that you're with us, Michael. And you have some interesting information about who is actually being proactive with setting up an estate plan right now as well.
We do have some interesting information, and I'm here to give a shout out to young adults. So I know normally we celebrate the 50 plus here at AARP, but I'm going to shout out to the young adults because they've really stepped it up when it comes to estate planning. So every year, caring.org does a survey across the country, and it's a wills and estate planning survey. And there are a couple interesting nuggets they found. The first one is the number of young adults 18 to 34 with a will has risen 50% since before the pandemic. And so the pandemic really impacted younger adults. The second nugget that came out of this survey, again from caring.org, is that those who had a serious case of COVID-19 are 66% more likely to have a will than those who haven't. So what ended up happening is I think COVID really lit a fire for younger adults and clearly lit a fire for those who actually experienced COVID. And it basically explained, it said to them, it's time to get my affairs in order. You know, after having endured this pandemic for this long, it is time to get my affairs in order. Now, unfortunately, the same survey said some people are still holding back from getting that estate plan done. And so I take a moment here to go through some of those survey results. The survey said, so you're holding back, you haven't really gotten that estate plan done. Why is that? Number one is I haven't got around to it, 40%. This number was at 38% last year. It's risen now to 40%. So that number is rising. Number two is I don't have enough assets, 33%. Number three is I don't know how to get a will. Of course, Michael's going to alleviate those concerns and really walk people through that. And number four is it's too expensive. And so we've got some myths to debunk here as far as, you know, I don't have enough assets, therefore I don't need an estate plan. We've got an information gap clearly here with people that don't know how to get a will. And hopefully, Christina, that we can motivate people to actually do it to alleviate that number one concern, which is, well, I just haven't gotten around to it. And, you know, I'm really interested to hear from our audience, right? And hopefully they call in and maybe they can share with us what their holdup is and some of the concerns they have when it comes to estate planning, because of course our audience, we always get such great education from our audience.
877-283-7570 is the number to call. You're absolutely right. We would love to hear from you tonight, and you might just be a winner as well. And this is kind of a heavy topic, but it is one that has to happen, and it has to be done regularly because some things can happen in life where you actually have to take a look back at that estate plan, maybe make some changes to it. But before we get there, Michael, we all know we should have a will, but many of us are not sure exactly what that means. And we just heard all the misconceptions. But when it comes down to its most basic purpose, talk a little bit about the importance of a will.
Sure. Everyone has an estate. And if you create a will, then what you're doing is dictating the terms and how you want your assets distributed. If you do not have a will, you will die intestate, and that means that the state will determine where your assets are distributed. So really, creating your legal documents allows you to control the distribution from the grave and make sure that those loved ones that you want to have those assets or whom you want these items to go to, make sure that you have that will so that your voice can be heard and not let the state be the determinant upon the distribution.
Yeah, because, I mean, after all, it's your hard-earned money. You're the one who's been working for it. You really just want to hand it all over to the state because you didn't spend maybe 15, 20 minutes in some cases to take care of a will. Okay. Well, we're excited to get this conversation going. All that's missing now is you. Give us a call tonight. We'd love to hear from you, 877-283-7570. We're going to pause for a quick break. When we come back, Michael Wallen is going to be here to take your questions directly. Plus, we've got coolers to give away. 5 lucky on-air callers tonight. We want to hear from you. Do you have an estate plan? If not, why is that the case? What's keeping you from getting that in order? 877-283-7570. Or if you were recently motivated, we'd love to hear that side of the story as well. We'll be right back with more Rural America Live with AARP after this.
Here are 6 items you should consider including in your estate plan. A will. This is the main component of your estate plan and ensures your property is distributed according to your wishes. Durable power of attorney. This person will act on your behalf when you are unable to do so. Beneficiary designation. You want to decide your beneficiaries. If you don't, a judge might make that choice for you. Letter of intent. It's a document left to your executor or a beneficiary, and it defines what you want done with a particular asset after your death or incapacitation. Healthcare power of attorney. This will designate another individual to make important healthcare decisions on your behalf. Guardianship designations. If you have small children, you want to make sure you decide who will care for them if you no longer can. For more financial information, go to aarp.org/money.
Welcome back to Rural America Live with AARP. Our show tonight, how to keep the family farm in the family. We are talking about estate planning and wills. How much do you know about this topic? Do you have a will or an estate plan in place? And if not, why? Maybe you've got a story to share about your own estate planning problem or success. We want to hear from you tonight, and you might just be a winner. We are giving away 5 coolers, and these are quality coolers. So pick up the phone and join our conversation at 877-283-7570. We would love to hear from you. And joining us once again, AARP Iowa State Director Brad Anderson, and our special guest tonight, Certified Financial Planner Michael Wallen. Now, this is a popular topic for our viewers. We're going to go to the phones in just a moment. We all know we should have a will, but many of us, like we talked about, we don't know a lot of the ins and outs. We're not all lawyers, for example, or financial planners for that matter. But for those with an estate plan, when is it time to revisit that plan? For those who actually went out, they talked to who they needed to, they put that estate plan in place, when do you have to go back in life and say, ooh, it might be time to update it?
That's a great question. I would state that if you've had a life change such as a birth, a marriage, a divorce in your family, if you've had a change in ownership of a business, or if you're selling a business, you would want to revisit it. If you've modified some of the beneficiaries, let's say you outlived one of the beneficiaries inside of your trust, you'd definitely want to go back there and make some recommendations or changes to that so that it can be distributed to the person that you'd want it to go to.
Okay, that's really important as well. And tomorrow's not promised to anybody, and so there's no reason to really wait on any of these things that we're discussing tonight. We're going.
You know, I had some
Yes.
experience with this personally because my mom recently passed away, and she had an estate plan, but she had got this dog, and to your point, the dog was not in the estate plan. So even the smallest things can cause an awkward situation at the end, because then the question was, well, do I get the dog? Does my brother get the dog? Does my aunt wanted the dog? Even a neighbor wanted the dog, right? Everyone wants this dog. We worked it out, but my point is, it really is important to kind of cross the T's and dot the I's when it comes to these estate plans to prevent those awkward situations on the back end.
Yeah, offer clarity if you can.
Yeah.
I love that you brought that. I'm sorry for your loss.
Oh, thank you.
Janice from Indiana joins us now. Thank you so much for joining us, Janice. Really appreciate you. Go right ahead.
I have 200 acres, 40 of which is in classified forest. The other is cropland. And I'd like to pass it on to my 3 children with the least amount of inheritance taxes. There was a will made before my husband passed away 25 years ago, but I didn't know if something should be updated.
Yes, Janice, I would encourage you to visit with the attorney that had prepared those legal documents for you in the past. 25 years is a considerable amount of time. I'm sure there's been a lot of changes that have happened in your family. And also it could even be state law changes that you would want to make sure that your will was in alignment with. You would also want to have a discussion with them possibly around a trust and having that property titled into the trust for estate planning, because that now gives you protection in some areas of asset protection. And also to make sure that it's distributed appropriately to your children in the way that you want it to. And those legal documents would help you get there. So I think you're on the right path if you would make that phone call and talk to a local attorney that could assist you with that.
Thank you so much for that call, Janice. We appreciate it. 877-283-7570 is the number to call with your question or comment tonight. We are going to Patrick in Texas. By the way, Janice was a winner. Congratulations to you, Janice. Right. Patrick in Texas, thank you so much for joining us. Go right ahead.
Thank you. This is Patrick from Texas. The only thing that I did here recently, I'm 72 years old, and the wife is at 70, and I had a mother that is still in a nursing home. She's going to be 97 next month. So, and she went to the nursing home about 10 years ago, and she and Dad had prepared it 5 years before that, and that she and Dad, we didn't know anything about it as well. She went in a nursing home as well. She's going to have to give the home to the nursing home and pay for the nursing home and all this. And we found out that they had it all figured out. And, well, we didn't lose the home. Yep. And now, recently, we did it. And I've got to wait 5 years now. I just did it here recently, and I've got to wait 5 years before if me and my wife get incapacitated and have to go to a nursing home, we'd have to give our place up. I've got 50 acres and a nice home, a nice with cows and all that, and I just I'm glad I did it, but we have to wait for 5 years. So.
Yeah, what Patrick's referring to there is the 60-month look-back provision. And what that is, and that's the 5-year duration that he's referring to, first thing they're going to do is liquidate their liquid assets before they would have to then sell their real property. But as long as they have liquid assets that would be able to pay forward for 50 or for the 60 months for the 5-year duration, then that piece of property would still not have to be sold at that point because that property is now out of their name. So again, that is a reason to be sitting down, talking to a Medicaid planning expert. Because that is part of using that trust document, getting those assets into an irrevocable trust. Completely different than a revocable trust, but getting it into an irrevocable trust so that 60-month time period starts counting.
Wow. Okay, thank you so much for sharing that story with us tonight. We appreciate it, Patrick. Our next caller is a winner. Betty joins us from Michigan. Congratulations, Betty. Go right ahead.
Yes, I'd like to know if a lawyer is more educated in this trust or your company.
Well, Miss Betty, I am not an attorney. I am a certified financial planner, which we take estate planning courses. But I would always encourage you that if you're getting legal documents prepared, then you would want to speak directly to an attorney because they're the only ones who can actually create those legal documents for you and give you advice on the best legal document to take care of the specific need that you have.
Okay. Congratulations on that win as well, Betty. Keith from Ohio joins us now. Thanks for joining us. Keith, go right ahead.
Thanks for taking my call. I'm 56 years old and married, and unfortunately, I do not have a will yet. I know I need to do that. My question is, even though I do not have a will, I do have designated beneficiaries on my 401k and life insurance and my other assets. Will that be valid, or because I don't have a will that be ignored?
That's a great question, Keith. And you're talking about the difference between contract law and state law. Contract law supersedes state law. So anything that you have on your contracts, a 401k, whether it's a life insurance policy, annuity contracts, bank accounts, anything that you have a designated beneficiary on, it is transferred, what they call simultaneous transfer of asset. That goes through contract law and it supersedes state law. And state law is where the will or trust documents would come into play.
Okay, thank you so much for that question. We're getting some great questions tonight, and we just started.
This is a review course for me for our program.
He's going to do some estate planning tomorrow morning, I would think.
You sure you don't want to take that bar exam and keep on going with your education? Okay, we are going to find out a little bit more about, kind of in the same vein, durable power of attorney. Power of attorney is so important, and we don't know how long we're going to have cognitive function. A lot of things can happen. Power of attorney is something that we're all familiar with, but we, again, don't know exactly what it means. Can you clarify that for us?
Sure. What I would say is there's 4 different terms that you need to be familiar with when you're talking about power of attorney. The first is that a ordinary power of attorney is just simply creating a legal document that allows another individual to act on your behalf, and that is an attorney in fact, and it's also called sometimes an agent, which they're working on your behalf. An ordinary power of attorney ends when a person comes incapacitated. A durable power of attorney has specific language inside of the document that allows it to supersede when a person loses their cognitive ability or they become incapacitated to act on their behalf. And you can create those for both financial as well as health care. And the other part is you can look at limited or general. And so limited, it's specific to a certain function that you want that individual to act on your behalf. Or a general would be working in a vast variety of different areas to work on your behalf. So those are 4 different terms that you would want to know about a power of attorney. But for our purposes, make sure that you're looking, if you're wanting it to supersede an incapacity for you, make sure that you set up a durable power of attorney.
That's the key word right there, durable power of attorney. Okay, 877-283-7570 is the number to call and join our conversation. We're still giving away coolers tonight. You could be a lucky winner, so give us a call. The lines are open now. We're going to go back to the phones where Carol joins us from Kansas. Thanks for joining us, Carol. Go right ahead.
We have a trust. Should we have a will also?
Well, do you have items that are not listed in your trust that you would want to have distributed? If so, those items you would want to have listed in a will that the probate court would then process. I would sit down with an attorney, the one that drew up your trust document. Most of the time when they create your trust document, if they're ancillary items, they will also create a will for you at that time, along with your durable power for finance and your durable power for health care. So I would recommend that you sit down with them and find out if there are parts of your estate that they may have omitted, or if they have included everything into that trust document. It sounds like a great time for you to sit down and have a review of your legal documents.
All right. And
now,
go right
one
ahead.
thing Michael, behind the scenes, you were telling us about how easy a trust can be once you get it set up.
Sure.
And I know I learned a lot about 20 minutes ago when you were talking, so I am sure our listeners would appreciate that too. Can you walk our listeners through what you were telling us?
Yeah, I believe it was Keith that was the caller, and he was talking about having a 401k, having some different contracts. One of the things that we sit down, and it's not a carte blanche rule across the board for everybody, but oftentimes when we're sitting down with accounts that people have, we will set that account up to go to the trust document. And then the only thing that the individual has to manage is the beneficiaries of the trust. And that way they're not having to keep up. It just does a lot of housekeeping for our clients so that they're not having to go out and remember all the different accounts they have. Now, you got to be careful if you have a qualified account and you have a surviving spouse. You don't want it to go to the trust, because then you're going to eliminate that spousal benefit of them being able to take the qualified account as if they had always owned it. But if you've got non-qualified accounts, definitely set that up, have it moved over so that you can streamline your estate planning there, and all you got to do is keep up with one document. You don't have to keep up with everything.
Yeah.
That one beneficiary change, that's it.
That's great
And
advice.
hopefully you're not changing those all the time.
Yeah. Well, not all families get along, so sometimes there's some changes.
It happens. It happens.
Mind your P's and Q's, yeah.
Donna joins us now from Ohio. Thanks so much for joining us, Donna. We appreciate you. Go right ahead.
Well, thank you for the call, taking the call. If you have a TOD we have a small farm, and if you have a TOD, does that supersede, can that be as good as a will? And does that keep that out of probate?
Yes, ma'am. A TOD means transfer on death. A lot of times you'll find that on even bank accounts. They'll be listed as a TOD or a POD, POD meaning pay on death. And what that is it's equal to a beneficiary on accounts, and it is contract law, so it will supersede the state law, which is when you get into the probate court distributing the assets. So TOD, POD, same as a beneficiary, that's contract law.
All right. Thank you so much for that call. That leaves a line open for you tonight, 877-283-7570. Maybe you just want to let us know what it is that's valuable to you that you want to leave to the next generation, or that you want to leave to, say, a scholarship. We were talking about how you don't necessarily have to let the state have that money. You can designate it in many different ways. And you were talking about a teacher in Iowa who actually left everything in the form of a scholarship.
Yeah, so Judith Lindquist was a teacher in Iowa for decades, an elementary school teacher, and saved her money. And this is what I was talking about, by controlling your legacy and taking control of it. She decided she really wanted to give scholarships to high school girls who were going into college. And so when she passed away, she left this fairly substantial endowment for scholarships for high school girls from 2 specific high schools in Iowa who were going to go to college. Now, again, this is what I'm talking about. You don't need to be, a country music star or a farmer or a millionaire to create an estate plan. You can be a school teacher and still have a really important impact on your community. And so that's why I love the Judith Lindquist story, and I think it's really important for everyone to hear who wants to pass down something to the next generation.
Absolutely. I love that as well, because you can't even designate where the state is going to put that funding, and they can put it anywhere they want. City council meetings, you know what I'm saying? So
Yes.
It's very interesting to see what it means to have that sort of power, to be able to say, okay, I know I can't take this with me, but I want to make sure that it's helping somebody else. And that's all you're doing when you're putting together an estate plan or a will. I want to give you that number to call in one more time. It's 877-283-7570. We're getting so many great calls. We still need to hear from you, though. We're going to go back to Kentucky. Sue is joining us. Thanks so much for joining us, Sue. Go right ahead.
Yes, thank you very much. My question is, my husband passed away 7 years ago. I'm a senior citizen. I'm 74, and I do not have a will for myself. And we have one middle-aged son who is 44, and he also does not have a will. And we are sharing a home together. How should I go about doing all of that? Who would know if anything happened to either one of us, where to go, where to find anything, or what would my son do, with anything that was left? That I would like everything to go to him, of course, but and then he can divide it out the way he wants, and vice versa. But family members live in another state. Mm-hmm. And so how would I go about notifying or having someone know when something happened to myself, or maybe I'd be the only survivor and it would just be me or be just my son? How do you handle that? Do you name someone? But how would they know about the will? How should I? And I know I need to do a will, but how should I go about that?
Well, notification is typically done by the attorney that is establishing the will for you. So upon your death and their notification to the attorney's office of your passing, then they would reach out to the beneficiaries of the will and who it's going to be distributed to. But you mentioned one thing in there, Sue, that I think it's really interesting, and I think that our listeners need to be aware of this as well as yourself. Leaving the estate to one individual and then asking that person to distribute it to a vast number of other family members, whoever receives it, whoever it is going to be the one receiving the inheritance, is also going to get the taxation if there is taxation. And then they're going to pay all the taxes and then distribute the after-tax estate or assets out to other members. That's not always a good plan. I would really take inventory of what you have and designate whom you want it to go to on the front end, because you don't want one family member receiving all the taxation, because that can really cause conflict later on down the road when they've paid the taxes and then somebody else is actually getting the after-tax benefit. So I would encourage you, first of all, take the inventory of all your estate and then determine who you want it to go to, and then have the attorney draw it up in that manner.
So Michael used that key word, inventory. And this is the time that I think I should plug some AARP resources. I think we're probably going to wait to the end of the show, but I'm just going to do it now because it sounded like Sue and her son were kind of both getting started in the estate planning process. And so if you go to aarp.org/AARP Live after the show, we're going to have a lot of resources for you. One of them is an estate planning guide. And so this is really 2 booklets. It's a lesson plan, so it kind of teaches you the ins and outs of estate planning, wills and trusts and all that stuff. And the second thing is a workbook. And so you can take that inventory using the workbook. It's all free.
Wow. And
it's all going to be on our website here after the show. And I really do encourage people to take advantage of that, because it is important to get that inventory taken care of, so you don't have the situation that I experienced firsthand with my mom's dog, or any situation really. And it can alleviate so many challenges down the road by taking these really simple steps on the front end.
They're important. And I mean, that's kind of the whole setback, is it's a daunting task to take on. I mean, already just getting your mind there, the perspective is important. But then when you think about all the paperwork and the time, this is a way for you to kind of sit back and say, okay, it's attainable. I can actually make this happen. AARP/AARP Live for those resources one more time. 877-283-7570 is the number to call in. Laverne joins us now. She is in Colorado tonight. Thanks for joining us from Colorado, Laverne. Go right ahead.
I recently moved from Missouri to Colorado, and they said in Missouri that my will would be okay in Colorado. But what do you say? Should I see another attorney here and have it reviewed?
I would encourage you to visit with an attorney there in Colorado, and just make sure that there's no state laws that would cause any impediment or hindrance in what you're wanting to have distributed and who you want it to be distributed to. Most of them will do a review directly with you on that. First consultation probably doesn't even have an expense. So I would encourage you, have it reviewed, and then at least give you peace of mind as you're moving forward with it.
Well, and you've made the point in previous shows that it's really important, because it could be free, right? That first consultation often is free. But even if you do need to get something written up, sometimes for smaller estates, you're only talking about $100 or $200, right? So it's very attainable.
The issue is most people will try or think they can't afford, and they will avoid getting their legal documents thinking it's going to be so expensive. It's not. What is expensive is not doing your legal documents, because that's where you lose tens of thousands of dollars, and it may cost you a couple of $100s to get the legal documents put in place.
Or your family members after you're gone, which is, you don't want to leave that kind of a burden for your family.
Sure.
Okay. We're going across the border, due north into Canada tonight.
Okay.
Where Carl joins us from Ontario. And Carl is a winner. Congratulations, Carl. Thanks for joining us. Go right ahead.
Yeah, thank you. I have 3 sons, and I have from one son, 3 grandchildren. I have quite a number of farms, and I like to make sure. How many generations can you lock it in?
That is a great question.
Even my great grandchildren, I might never see them, but I want the farmland's just gone ridiculous, and it's gonna, in 2 or 3 decades, Lord knows what it's going to be worth.
Yeah, Carl,
I want it to stay.
What I would encourage you is you get the legal documents put together, and then teach your children to make sure that they get the legal documents. That way they have a plan in place that then sends it down to the next generation. But you can establish, if you have living heirs today, they can be a part of that trust that you're creating today. So, but I'm not versed in Canada law, so I highly encourage you to sit down with a competent attorney in your area and have them draw it up and give you some guidance based upon Canadian law there.
Hey, you took a swing at it. I think that you hit it out of the park. Very nicely done. I was wondering how you were going to go about that, but yeah.
International shipping for that cooler, too.
That's right.
Are we able to do that?
We got that covered. We got that covered.
We do? Okay. All right.
We're going to go back to the phones where Dave joins us from Illinois now. Thanks for joining us, Dave. Go right ahead.
Yeah, I own about 375 acres, and I farmed it for 32 years, and I have a truck and an excavating business and a lot of assets. But I only have one son, and he's 29, and he doesn't have a relationship with me, and it breaks my heart that I can't leave this farm to him because he would probably just turn around and sell it. I'm just like nothing in his life, and I don't know what to do. I want to try to put it in a trust and pass it on to my grandson. He's got one son, and he's 2 years old, and I've only seen him for 5 minutes. And it's a sad situation, and I just don't feel comfortable leaving the real estate to him because he'd probably just turn around and sell it. And that's not my thinking. I want to tie it up so he can't sell it.
And Dave, and my heart goes out to you in that. I would say that, always remember what's happening today doesn't always mean it's permanent. There's always hope and change. And so setting up a trust allows you to be able to control that asset from the grave. So in that trust, you can set up conditions. And if those conditions are not met, then that property could be left to a charity. If that is still a working farm and it is managed out for other people to work it, you can always create an income stream off of it that could be of benefit to your son or to your grandson. But you're controlling it. You get to put in the trust document the conditions in which that you would want to have it distributed. But ultimately, if those conditions are not met, you can always have a secondary benefit, which would allow that to go to a charity of your choice and make sure that there's good that comes from it.
All right. Yeah, praying for you and your family. And
It's a tough situation.
yeah, it's tough. It's real though.
It's real.
Nobody in this world is spared from having family members that they don't get along with perfectly. It's just the way that it is. We all know about that. And that's what this show is about, is to really bring that to the table tonight so that you can really kind of sit back and look at, hey, where do I want my final assets to go? Yeah. That's what we're here for tonight. We're having a real conversation, and we're giving out coolers. We're going to pause for a quick break. Two separate things, both going to make you better tonight. Again, our phone lines are open, and we want to hear from you. 877-731-6733. That's actually not the right number. It's 877-283-7570. She's done this show a time or two. We'll be right back. We're taking more of your calls right after this quick break. And like we said, we want to hear from you. Every single story that you have to share with us, every question, it adds something to someone else's life. So give us a call. We'll be right back with more Rural America Live with AARP next. Welcome back to Rural America Live with AARP. We are glad that you're with us tonight. We still have a cooler to give away, so let's go straight to the phones. We are going to the Four Corners now. Ooh, Heading out west where Jean joins us from Nevada. Thanks for joining us so much, Jean. Go right ahead.
Hi. My question is those packets of the do-it-yourself will that you can get either online or, at the post office stores, are those a legal document if you were to go and get it notarized, or do you have to use an attorney?
Now, you can actually create what's called an holographic will, and that's where you, in your own handwriting, you draw up what you want your will to be, but you do need to have 2 independent witnesses to witness your signature to that will. And so holographic wills have stood up in court as just as good as what an attorney has drawn up for us. But the key difference in that is attorney is trained to help you identify the areas that you may not have thought about. Residual clauses, making sure that sometimes people name specific items like their current car. Well, then if they get rid of their car and they buy a new car, then that car is no longer in the will. So the attorney's going to help you make sure you've got clauses written up in that document to protect you. So it's a benefit to go see the attorney.
Excellent question, though. What a great question.
It's a great question.
Yeah.
We're going to Georgia now, where Ronnie joins us from Georgia. Ronnie, thanks for joining us. Go right ahead with your question.
Hi, and I'm sure my situation is rather complicated. I have a 30-year-old special needs child, and so my little bit of research tells me I need a special needs trust. But I'm curious as to what the panel may think, or what would be some of the top things I should consider in a special needs trust.
We were just talking about
We
this.
were just talking about this at the break. Definitely you need to have a special needs trust. There's specific language inside of it to take care of that loved one later on, because oftentimes what I hear, Ronnie, is individuals will tell me, well, in the event that I pass away, our special needs child is going to live with another sibling or an aunt or an uncle, a surviving loved one. But it's not always the case that that environment of that individual's home may not be beneficial to that special needs individual. It may not be the right conditions for them. Setting up a trust, making sure it's properly funded, gives the resources there that the most harmonious environment can be established for that loved one, and also make sure that if they do have siblings or the other relatives, they can visit them on good terms as well, because it's not putting a strain on anybody at that point. So definitely reach out to an attorney and have a special needs trust drawn up for that loved one.
Well, and the same is true if you've got an older relative living with you as well, right? So if you've got a parent, a mom or a dad with some health issues or some mobility issues,
Sure.
the same holds true.
It does. What you're doing is you're planning. You're thinking about all the different scenarios that could happen. And oftentimes, if we're younger and we have our parents living with us, we think that we're going to outlive them. That's not always the case. So you need to make sure you have provisions and a secondary plan in place that can take care of them and give them the best family environment, the best home life that they can have at that moment.
I love that. Okay, and congratulations, Ronnie. You are a winner tonight. Ron from Texas joins us now. Thanks so much for joining us, Ron. Go right ahead.
Yes, my question is in reference to owning a business. We own a ranching business. Mm-hmm. It's a full-time business. And in terms of passing it on, where you want it to continue as a business, my wife and I, we each have a will, but in terms of addressing the business situation where you want to pass it on as a continuing business, from listening to some of the previous callers tonight, I assume a trust would be something other than a will that would maybe satisfy whatever is needed to have that situation exist, where you would pass on a ongoing business to the descendants or your descendants.
You would, and I would encourage you to have a written succession plan to go along with the trust. A succession plan is going to allow you to transfer the ownership as well as the management in the most effective and efficient manner possible to that loved one. But it can also spell out, let's just say that you have multiple children and maybe one of the children do not want to be a part of the cattle business. It may not be something that they're adhered to or they have desires for. In setting up a succession plan and a trust, you can also create an income stream to that individual so that you don't disinherit them. But really in that, Ron, I would encourage you to really draw up a succession plan, and you can meet with a business planning expert along with an attorney to get those two different documents created for you.
All right. Thank you so much for that. Call 877-283-7570 is the number to call and join our conversation. We still have time to hear from you this evening. Nancy joins us from Georgia now. Thanks for joining us, Nancy. Go right ahead.
My question is, we did an online family law software will, but we have a will, so that's good. But where is the best place to store your wills? And who should you give copies of your wills to?
Well, I would definitely make sure that I had the will in a digital format. Your attorney should also keep a copy of that will for you. But there's many digital cloud-based vaults. AARP may even have resources, to look at there. But if you have a safe, not necessarily a safety deposit box because you can't get to it unless the bank is open. But if you have a safe at home, I would have it in there. The beneficiaries of your will, I would make sure that those individuals also had a copy, so for safekeeping.
Yeah, and as we're talking about these lock boxes, I think it's important to point out passwords and the importance of passing down these passwords because if it would save so many headaches down the road if you just knew the login accounts for bank accounts and credit card accounts and utility and all the things. So you're not having to mail death certificates and go through all of those problems. So there are online tools that can where you can have collect all your passwords into one account and then just give that key to whoever you are passing your estate down to. That's number one. Number two is we haven't talked about advanced directives, and I do know AARP does have on our website a place where you can go for each state and you can have a template for your advanced directive and print that out and get that taken care of as well. So living wills are important, and we've got some resources that are totally free on that as well.
AARP.org/AARP Live. That's the website. Okay, thank you so much. This has been such an informative show. We're not done just yet. We still have time for your call tonight. 877-283-7570 is the number to call. Toby joins us now from Michigan. Thanks so much for joining us, Toby. Go right ahead.
Thank you for taking my call. I can feel the pain of the gentleman that doesn't see his grandchildren. I have 5 I don't see. And that's one of my questions. How do I pass something on? I'm 72. My wife is in a nursing home. So I need, she's going on Medicaid at the end of the month. Everything will be supposedly taken care of there. But it's, our home, I guess, is what we really have left of value, and the property in the home, my tools, my guns, things like that. I'm wondering how like passing them on or disposing of them or, just finding a pathway for that, because we do have durable power of attorneys and all that stuff is being made up as we talk, but there is no will.
Well, Toby, are your grandchildren, are they of adult age or are they still minors? And we may have lost Toby there. If your beneficiaries or the people that you want to pass on to are minors, then you have a situation where household items may not be, that you might have mentioned there, may not be able to be distributed to them at this time. That would mean you may want to then look at getting a trust, because a trust can dictate when you would be able to distribute those, or when the trustee would distribute those items to those loved ones. But it does determine whether or not you're dealing with a minor child or a person that has reached age of majority.
Okay, thank you so much for that call, Toby. That brings us to Chris from Colorado. Thanks so much for joining us, Chris. Go right ahead.
Hi, my question is for you. How have you seen people do estate planning when there's multiple siblings involved and there's only one involved in the operation and would like to keep the operation going? Or in a sense, I guess, how would the real estate be split amongst the siblings with the one involved and the ones that aren't?
Well, if there's other assets, you can accumulate all the assets together at the time of death and distribute other property, maybe even investment accounts or savings accounts, and then keep the farm in the family to the individual that wants to run it. You can also disperse a portion of income. If the farm is generating revenue, then you can use that as a buyout to those other siblings as well. But you do have the ability to go through there and split those assets, but look at everything collectively as a whole and then disperse the amounts. But also, you have to look at revenue or operating capital to make sure that the farm does not suffer during that distribution.
Okay. Thank you so much.
Great advice, Michael. This is great free advice, by the way. So you got 5 minutes to call in and get this wisdom from Michael.
I've got 2 more good answers in me. That's it. I need 2 more good answers.
It's like a graduate level class here in estate planning. It's amazing.
It's fantastic. He'll be back again. We're hoping anyhow. Yes. Okay. Well, we have a few moments left for final thoughts. Michael, let's start with you.
Yeah. Really, as we look at the show, I think we've covered really 4 Ds that I think everybody needs to be thinking about as you look at your estate planning. The 4 Ds that ruin estates is disability, divorce, death, and disease. The 4th D, we've always talked about the first 3, but after COVID, you really need to consider how disease can go in and affect the rest of your estate. So it's very important that you get those legal documents in place now, because when something strikes, something happens, you don't have the time to be able to go back and get them after the fact.
Mm-hmm. And have you been busier, I will ask you, since the pandemic?
We have. Our clientele has been coming in. The awareness and the need to have trust documents, wills established, has skyrocketed in our practice.
Wow.
So our attorneys have been very busy creating those documents and helping our clientele.
Well, it's good. People are actually getting their ducks in a row.
They must be listening to the Rural America Live show here tonight.
We sure hope so.
Right.
What are your final thoughts for us tonight, Greg?
Well, speaking of working hard, we've got our tax-aide volunteers out there, and so tax season is upon us, and so this is a free service that the AARP Foundation offers. If you want to check to see if there's a tax-aide site near you, just go to aarp.org/tax-aide. And again, you can bring your documents to our trained volunteers.
What?
They're trained by the IRS.
My goodness.
It's a free service, and they work really hard, and they do a great job, and they save people lots of money. So tax-aide.
That's amazing that you're doing that. That's amazing that AARP is doing that. AARP.org/AARP Live. Thank you so much, Brad. Thank you, Michael. You two are wonderful. Our viewers, I'm sure, are thankful. So many great calls tonight. That about does it for us. But make sure that you join us next month, April 21st. We're going to share the latest frauds and scams making their way across the country. Thank you so much for joining us on Rural America Live. Wishing you and your family a beautifully blessed evening.